Hi everyone, I'm Ashani Kankanage. Today we'll be talking about law of persons. So when we are comparing law of persons as a subject, when compared to other subjects, it's actually kind of easy. It looks easy because we are familiar with it. Today I'll be talking about a main topic, which is marriage. Before going into the main topic, I would like to just give you a general idea of how the law of persons is governed, what are the sources and stuff. Law of person is governed by the general law, Muslim law, Kandian law, and the Thesawalamay law. So when it comes to the general law, normally the general law applies to both Tamils and low country Sinhalese. So the general law is actually influenced by both Roman Dutch law and English law. And when it comes to the Muslim law, it applies to all the Muslims in the country, and it is applicable to the Muslims actually. When it comes to Thesawalamay law, it is only applicable to certain number of Tamils. So therefore, the Tamils has the option of the general law. When it comes to the Kandian law, the Kandians can follow the Kandian law, but they have an option either to go with the general law or to go with the Kandian law. So when you sum up the whole introduction part into this, it's basically very easy to understand. And also I would like to make a note of one thing, that when we are going through the syllabus, all the topics on the syllabus, I'll be mentioning about certain key statutes, and make sure to keep in touch with them so that it will be easy for you all to understand what I'm actually talking about. Yeah, so let's move on to the main topic, which is marriage. So when it comes to marriage, marriage is not a joke. It has serious impacts on the lives of the entering parties. So what is actually a marriage? So what does marriage means? So marriage means it is a voluntary agreement which is entered by two consenting parties. So it has a contractual nature, but we always have to make sure that marriage has certain differences when it is compared with an actual contract. So let's move on to the main key components that I would be talking to you all today. There are four main key components that I would be mentioning. That is, the first one would be formalities. The second one would be the registration of a marriage. The third one would be customary marriages, and the fourth one, finally, I would be talking about marriage by cohabitation and repute. So yeah, let's move on to the main, one of the first main components, that is formalities. So under formalities, we are going to discuss about capacity to marriage, or certain requirements that you need to fulfill in order to be eligible to go into a marriage relationship. So under that, there are four subcomponents, and those are the minimum age to get married, the prohibited degrees of marriage, thirdly we have subsistence of a prior marriage, and finally we have the consent. So if we go on to the first subcomponent, which is minimum age of marriage, the MRO, section 15 of the MRO and section 4 and 66 of the Canadian Marriage and Divorce Act gives the minimum age as 18 years. So if you're getting married, the minimum age that you should possess is 18 years. But when it comes to Muslim Marriage and Divorce Act, it's quite silent when it comes to minimum age. They don't specifically talk about minimum age to get married. But section 23 says if a girl has not yet attained the age of 12 and she is going to get married, she'll have to get the notification, or she'll have to notify, or she'll have to get permission from the cause. That's all what they talk about when it comes to the minimum age of marriage. And also, let's move on to the second point, which is prohibited degrees of marriage. So when it comes to the prohibited degrees of marriage, section 16 and 17 of the MRO talks about the prohibited degrees, mainly 3 points. So when it comes to the prohibition degrees, there are 3 points. Those are, the first one, you can't get married to a person who is a direct descendant to yourself. And the other two instances are basically, now if you take the female side, you can't get married to your brother who can be either full or half blood. You can't get married to the son of your brother or sister who can be half or full blood. You can't get married to your son, who your son means your stepson. And also you can't get married to the widower of your own daughter, mother, grandmother, or your grandchildren. So it applies the reverse, or it applies reversely to the male side also. So those are the instances or the prohibition degrees that you have when it comes to the marriage according to the MRO. And section 17 of the MRO goes on to say, if you get married while knowing the consequences, it will be an offense. And also when it comes to the Canadian Marriage and Muslim Marriage and Divorce Acts, they don't prohibit the degrees of the marriage between adoptive children and adoptive parents and between the adoptive children. But when it comes to the Penal Code, section 364 A1A, it properly says it is incest if a marriage between adoptive children or adoptive relations happens. It is the offense of incest. So basically, when you take the general idea, the penal code applies to all communities irrespective of their personal laws. So if it would become incest, if even though they have not mentioned in their certain personal laws, it would become incest if they have marriages between the adoptive relations and the children. Yeah, so let's move on to the third subcomponent, which is subsistence of a prior marriage. So when it comes to the subsistence of a prior marriage, according to section 18 of the MRO and section 6 of the Canadian Marriage and Divorce Act, if there's a prior marriage which has not been legally declared void or legally dissolved properly, the second marriage would not be taken as a proper marriage. So it would go under the offense of bigamy under section 362B of the Penal Code. But when it comes to the Muslim law, again there's some certain differences when compared to the general law. According to their law, they can go on to 4 valid marriages if the person can prove that he has a financial means and he has a capacity to satisfy all his 4 wives with the marital obligations. But according to section 24 of the Muslim Marriage and Divorce Act, after the from the second marriage onwards, the qazi has to be notified of the marriages that he is going to have. Now when it comes to this instance, you have to make sure. Now there are certain case laws which can be discussed under this topic, mainly the Kasi Muhammad versus Benedict, Abhay Sundara versus Abhay Sundara. So when you take the case of Abhay Sundara versus Abhay Sundara, it is given much more importance, and it will be discussed in the coming topics also. So make sure to go through those cases and get to know the facts about those cases, because when it comes to questions, you have to support your answers with case law. So make sure to refer those 2 cases, which is Kashi Muhammad versus Benedict and Abhay Sundara versus Abhay Sundara. Okay, so let's move on to the final subcomponent, which is consent. So when it comes to the part of consent, according to section 334 part subsection 4 and 35 of the MRO, you have to the way you can show your consent that you are actually willing to get married is being present at the registration and signing the register. So when it comes to the Muslim law, actually it's not the bride who signs the registration, it is her wali or the wedding guardian, or the person who is as the guardian who actually signs on behalf of her. So when it comes to a Muslim nikah ceremony, what actually happens is the bride is not signing to her wedding, actually the registration. It's the wali who signs on behalf of her. So there would be her wali, the groom, and the person who conducts a nikah ceremony during the registration ceremony of a Muslim. So when it comes to the consent, parental consent is no longer needed, because the minimum age of marriage is 18, which is the age of majority. So you don't actually need the parental consent anymore. And also now when it comes to certain instances where if the child is not actually 18 and the parents have already given their consent, that doesn't mean the child can get married. According to the law, the child cannot get married, because in order to get married, even though the parental consent is there, she or he has to attain 18 years and parental consent is no longer needed. Yeah, so let's move on to the next main component, second main component, which is registration. So according to section 41 subsection 1 of the MRO, we actually it is not actually mandatory to have a registration for your marriage. And even in Muslim law, if the sect recognizes their marriage, the registration is not compulsory. But registration would actually give you written proof. Even if you have to go to courts to prove something, it would be actually easy when it comes if you have done a registration. But it's actually not mandatory. So we will move on to the third component, which is customary marriages. So the MR actually doesn't have a certain section talking about customary marriages, but under the general law, the court recognizes both registered marriages and customary marriages. But the Canadian law does not actually recognize any unregistered marriage. But then the Muslim law also recognizes customary marriages, but then customary marriages does not mean that you can get married in any way you want, but then you have to perform some customary ritual that your certain religion or your certain congregation or the community actually recognizes. For example, if you take now if you are a Catholic, you have to solemnize your marriage in the church. If you are a Buddhist, you can go and solemn your marriage through the Porvo ceremony. If you are a Muslim, through the Nikah ceremony, and if you are a Hindu, by tying the Thali and etc. So when it comes to these kind of topics, there are certain different various case laws. But then what I am telling is it's actually enough for you to study 4 to 5 main cases, know about the facts, and it would be much more. It would actually be useful for you. You don't have to study 10-15 cases. So like cases like Tigaraja versus Kurukul, King versus Perumal, and also Vijay Gunwardana versus Gracia Catherine. So these are like one of the main cases, and the cases which would be easy for you to study. So make sure to go through these cases, and actually 4 would be enough. Yeah, so the last part, that is the last key component that we are talking about, that is marriage by cohabitation and repute. So when it comes to this, if two people are living together and their relations and the friends out of them thinks and recognizes them as a married couple as such, then they are presumed to be a married couple even though they are not married. This is just a presumption, and this presumption is actually used to prove customary marriages. So earlier there are 2 instances. In the earlier times, this presumption was actually raised even when there was no evidence of them performing customary rituals. Like if you take cases like Tisalhami versus Nonohami, Valliyamma versus Annamma. So if you take those cases, it is properly proven even when there is no evidence. The presumption was actually raised. But in the modern times, it's actually different. Now if you take cases like Sediris versus Dabarera, now in those cases the presumption is actually raised if they have only performed the customary rituals. So when it comes to the present times, you can only raise the presumption of marriage by repute if they have only performed the customary rituals. So these are the main things that you can talk about under all these 4 key components that I talked to you all about today. So let's move on to the past paper questions, because at the end of the day you guys will be writing for the exams. So while knowing the theory and while studying the knowledge, you should be able to know how to answer the questions also. Okay, so when you go through the past papers, the very recent past paper, which is October 2019, they have asked to write short notes with regard to this lesson. It is first one is capacity to marriage and prohibited degrees of marriage. Make sure you don't write very long answers, because it is just 8 marks. So don't waste your time writing pages and pages. Make sure to make it summarized. When it comes to capacity to marriage, just make sure that you write the sections and certain case laws if needed. And when it comes to the prohibited degrees of marriage, make sure you mention all the 3 instances, and also about the instance where it differentiate from the penal code section. So when you write all those sections which I mentioned earlier, I am so sure it would be enough for you to get 8 marks. So don't write long answers, because it's just again 8 marks. And again, we can see questions about this lesson as such is again in 2017 October paper, and again in April 2017 paper. So again, there's a pattern all the time. Those 2 years, those 2 actually papers, they have asked about the Abhay Sundara versus Abhay Sundara case. So can you remember, like in the earlier discussion I told you all, Abhay Sundara versus Abhay Sundara case is very important because there's a difference in the judgment. It is a very important case. Make sure to go through the facts of the case. Just make a summary or a small note that would actually be enough for 8 marks. Not that you have to write the whole law report as such, but then make sure that you know the facts of the case and what was the judgment earlier, and why is this case more important, because there's a difference. No? So make sure that you know the difference of this case, and make sure to elaborate more on it, so that you will be able to make the answer more appropriate. So that would be up for today. Let's call it a day. Thank you so much for joining with me. I hope this session was useful to you all. Thank you so much.